Here's the proof of postage. Anyways, this is county court. Mind you, I'm going to tell you a little bit of law of what I know, okay? I'm not an attorney, but I have been studying the law quite extensively for several years. So, county court cannot rule on any matters judicially in jurisdiction of subject matter laws under jurisdiction for county courts. They cannot order any competencies. Can't. They have to refer their court case over to a district court who would have authority over state matters. Okay? This is only county matters. District matters would be more of state matters. Okay? This is basic law. And this Valerie Haynes doesn't know this. This is what scares me about judges and lawyers. They don't know the basics. I think we should all sue DU Law School and all the law schools for this kind of crap. But anyways, so to clear up Joe's delusions, competency. The judge has here only competency, not sanitary, which means people are bums. They are not presentable to go to court. They need a shower. They need a haircut. Those are the basic things that CMHIP does. They need some clothes. They need things that they could be presentable in court. Or mental conditions like schizophrenia or multiple personalities or Tourette's, where they're so, like, having such an extreme episode that they can't sit, they can't speak, they can't think about what's going on, they can't rationalize because they're caught in their other world. Okay, mind you, no check, no check. You can tell I'm definitely sanitary. Then, and I can think, speak, and rationalize. It doesn't mean you can't proceed in court if you have a mental illness. You could be seeing spiders on the wall. You could be having a full-blown schizophrenic episode, but if you can still sit there and keep your mouth closed and not run around the courtroom, and you still can see, like, know what's going on, where you're at, what's happening, that you're in a courtroom, you're having a trial, you can still proceed with mental illness. But it's only if it's deparing you to where it's disabling you to just be calm in the courtroom and know where you're at. And that the judge is the judge and the DA is the DA and that you're you, and that's all it is. So here it's just competency. So competency means think, speak, rationalize. That you know that you're in the courtroom. That you know what's happening. You know the basic law. Well, this judge says that she wants competency for this malicious prosecution where CMHIP has filed fraudulent cases where Caleb Bouvet, the district attorney in 15 CR 1287, conspired with CMHIP filing this malicious prosecution to try to taint my character. And they even forged a magistrate, Dorothy Radakovich's name. But yet she's saying I'm not competent to the subject matter and what occurred? Well, there's no crime. Underneath the state and federal laws, it states that in any private dwelling, any private property, any government property, which in the court case I filed the statutes, you can record at any time if a crime is occurring. And be it that a legal document was served underneath the personal service laws, I think it's Rule 4, you can record and picture, no matter if it's government property, private property, and even if it's posted, no recordings, you have under personal service the rights to record to prove you served a legal document, of which I served a legal document in this case, of which I caught them at a crime. And they lied about witnesses saying that these people saw this crime and they made reports against me when they did not. We got the people recorded saying they did not report, as this case fabricated witnesses. And yet she's saying I'm not competent. She wants to see if I'm competent to this case. This is idiotic. This lady needs to be behind bars. All of them do.